Thank you, ladies. We have reached a decision. I'm going to tell you what that decision is first, and then I will explain how we have got there. In relation to the claims of harassment, the two claims of harassment and direct discrimination, we are satisfied that there was discrimination, and we unanimously agree on that. In relation to the claim of constructive dismissal, we, by majority, agree that their constructive dismissal has occurred, and therefore both the claimants' claims are upheld. Let me explain how we've got there, please. The claimant worked as an estate agent for the respondent Pontypandy Estates from March 2015 until her resignation on the 5th of March 2019. She brings claims against the respondent in relation to harassment and direct discrimination. That is that in November 2018, the claimant says she overheard Mr. Kevin Moore making a comment to another colleague about the appearance of a female, whether it was a client or a celebrity is in dispute. The claimant said he was being inappropriate, but Mr. Moore said, "It's only a joke, love, don't tell me you're one of those feminists." In relation to the second allegation in December 2018, it's alleged that the claimant was preparing to leave the office when Mr. Moore asked if she was going to the Christmas party and said, "Maybe it will be your lucky night and you'll see me under the mistletoe." The claimant said it was not appropriate, and Mr. Moore replied, "Oh right, you're a feminist, aren't you? Probably a lesbian too, I know your type." The claimant attempted to leave, and she says as she attempted to leave, Mr. Moore groped her bottom and called after her, "Don't be shy, you know you love it," and then made a comment in relation to her being a peach. The claimant also claims constructive dismissal. She says that not only these two allegations of discrimination, but also the way her grievance was handled, and the fact particularly that she wasn't given an opportunity to contribute to that, and the way it was handled by Ms. Jones, who also was the person to whom the complaint had been originally made it unfair, and therefore she resigned. In relation to the law on these sort of cases, direct discrimination is defined in the Equality Act, Section 13. A person discriminates against another person if, because of a protected characteristic, A treats B less favourably than A treats or would treat others. The burden of proof is, of course, on the claimant to show there are facts from which we could decide that an unlawful act of discrimination has taken place. And if the claimant does establish such a case, the burden of proof shifts to the respondent to show a non-discriminatory explanation. In relation to harassment, it's Section 26 of the Equality Act. Did the employer engage in unwanted conduct relating to sex or of a sexual nature that had the conduct or effect of violating the claimant's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for the claimant? I remind the parties that the question is whether it had the conduct or, so the conduct had the effect or the purpose of violating the claimant's dignity. And in deciding that, we need to take into account the claimant's perception, any other circumstances, and whether it was reasonable for the conduct to have that effect. In relation to constructive unfair dismissal, there must be a serious and repudiatory breach of the contract of employment. That's the case of Western Excavating and Sharp. It's a very high threshold, and it's not even enough to show that the respondent acted unreasonably. It has to go further than that. The question for the tribunal is, whether the employer, so of course that's the respondent here, without reasonable and proper cause, conducted itself in a manner calculated and likely to destroy or seriously damage the relationship of confidence and trust between employer and employee. That's the case of Mahmood and Bank of Credit and Commerce International. And the burden is on the claimant in this case, and it's an objective case. So just in relation to the facts, as we've said already, the claimant started work in 2018. In 2015. We're looking at 2018 in this case. And in relation to the two items that we're asked to make decisions on, firstly, in relation to November 2018, we do not find that the first part of the first allegation in relation to the celebrity, and we find that it was a celebrity that Mr. Moore was talking about, constitutes an act of discrimination or of harassment. We find that that was part of the workplace banter that we've heard evidence of, and it was not unwanted conduct, and objectively it should not have provided a hostile environment or created a hostile environment for the claimant. However, it went further, and when Mr. Moore did make a comment about the claimant being a feminist, that clearly was directed at her. It clearly was unwanted. She complained about it, and we find that that was an act both of direct discrimination and of harassment. In relation to the second allegation, we're asked to make a decision on what actually happened at the time. We do prefer the evidence of the claimant over the respondent's witness, Mr. Moore. We find that the allegations as alleged by her did occur, including the groping allegation, notwithstanding the fact that she did not report it immediately. We accept the fact that it was a very difficult position for the claimant to be in at the time, and therefore it's very clear, we say, that that was an act of harassment and direct discrimination. There can be no question that objectively it wasn't unwanted conduct leading to a hostile or intimidating environment, and therefore we find for her on that point. As Ms. Moss has quite rightly said, it is mostly the case that when allegations of harassment are found, then it will contribute very highly, if not completely, towards a fundamental breach of contract. However, we have to go on to decide whether or not the claimant gave the respondent enough chance to deal with this matter. We do find that although in principle it might not have been a problem for Miss Jones to deal with the investigation, given that she had already was effectively a part of a witness or partial witness to what had happened at the time, we find that her attitude, however, was the problem, and that she was not willing to find against her colleague, Mr. Moore. We find that she was sympathetic towards him throughout and was not sympathetic towards the claimant, and she had effectively already made up her mind. However, we consider that the most important part and the most significant part of the allegations against the respondent in relation to the grievance is the fact that she wasn't given an opportunity to come to give evidence. We accept the fact that it was inappropriate for her to come to the respondent's premises, and it would have been very easy in our finding, although as I said this is a majority decision, it would have been very easy, we say, for the respondent to have either met her in some neutral location or to have gone to her house. We didn't have any evidence from Miss Jones as to the supposed difficulty and busyness of the time. We would have expected to have some very clear evidence of that if it really was the case that she wasn't able to take time to do that. And we also don't find Miss Jones's evidence credible that she had tried to phone on numerous occasions, because we find that the claimant would have and wanted to take part in this matter. In relation to the fact that she didn't appeal and the fact that she didn't mediate, we do not think that takes away from the fact that there was a fundamental breach which she responded to by resigning. She did not jump the gun. It was clear, and we accept the evidence of the claimant, that she was in a position where she didn't think there was any point in going forward because her allegations had not been taken seriously. And in particular, we do take into account the fact that the respondent did not suspend Mr. Moore, did not remove him from the premises, and did not even think about, it seems, initiating a disciplinary procedure or an investigation in relation to that. So for all those reasons, we uphold the claimant's claims.
Thank you.
Thank you, sir.